Our Supreme Court, by the way, is not supposed to be a fact finder. Facts are found by the trial judge. I gather that your Supreme Court does more fact finding than we do. For example, one of the controversial decisions, I Googled you and I found out it's controversial decisions. One was when the court, he was on a panel of 3 judges that authorized the Israeli Defense Forces to use live ammunition at the barrier between Israel and Gaza, in which a number of people were killed recently. So is that right? Did I get it right? You were on that opinion, and it was some notoriety there.
Okay. So
tell us about that.
Okay. So first of all, you're right saying that we are more flexible with the facts rather in comparison to the U.S. Supreme Court. Secondly, you have to understand, again, there is something very special and unique in our Supreme Court that in such cases, you can file a petition. It's not like in the United States that it goes from downwards to down up. You go straight to the Supreme Court in such cases. In a moment, if we'll have time, I'll explain why it is like that, and it has historical reasons as well. But usually we do not comment on our judgments, and I wrote the main judgment there in this case. And you have to understand the situation, and we got affidavits, and so we fixed the facts there. And you have to understand, in that case, it just happened to be that thousands of Palestinians made demonstrations on the fence between Gaza and Israel, and it looked as if it's civil demonstrations, but they didn't come with flowers. Most of the people didn't come with ammunition, with guns, but there were active military Hamas people in the crowd, and Hamas organized all those demonstrations. Now you have to understand, when about 15,000 people are demonstrating near the fence, and I'm trying to go in, they called it civil demonstration.
Disobedience.
Or disobedience. And once they start running into the fence, the question is what you have to do according to law. There was no such, it's now, my judgment is a worldwide precedent, because such a case never ever came before any Supreme Court before. I based my case, there was, it's very interesting, there was a Red Cross conference, and a professor has raised this question theoretically. What happens? And he said, in this Red Cross conference, that in such a case, if it will occur, I don't know whether they got the idea of the professor. He made a theoretical question, but then the answer was that in such a case, you are allowed to shoot the people in the theoretical case. And I based my judgment on the theoretical case. Now, they have claimed that it's just civil disobedience, but we found out and that the people who were killed, sometimes you miss, but 80% of the killed people were, just happened to be, officers of the Hamas. So, and that we knew when we heard the case. So, first of all, I based my case on Red Cross conference, which and was adopted by the Red Cross. Secondly, the fact was that innocent people were not found killed. Just, I say 20% were, let's say, it's either we didn't find who they were or they were, but 80% of the killed people were Hamas officers. And in such a case, you have to decide what to do, because the other alternative is to let them in, and then they can, kill the settlers in the other side, or army soldiers. So that is the dilemma that we had. By the way, that case you have asked, it was filed. The petitions were filed to the court. We heard it within 3 days, and we issued a full judgment with 50. I didn't sleep at all, though. But we issued a judgment within another week, and now it's been cited all over the world. And I can tell you that the many U.S. jurists in the universities support our judgment. There is, of course, there is also criticism. I wouldn't deny the fact that there is also criticism, but and then we said that in the other 20% of the cases that we don't know whether the people, it's ex post facto, we don't know whether they were military activists of the Hamas. Still, if there was a mistake, or sometimes you miss the target. It also happens. All those cases that should be checked by the army in order to improve the checks and balances next time, and to draw lessons from what happened there. And really later on, first of all, for a while it stopped. Unfortunately, in the last week it started again, so in heavy numbers. But that is the situation, and it's true that in such a case we have to fix as much as we can the facts as well. And again, you have to understand that in those cases it's something that never ever exists in any other court in the world. That during the time of so-called quasi-war, the Supreme Court is hearing the case, and you don't have it in any other court. From many other doctrines like unjusticiability, or because some of the organization. One petitioner was the civil rights organization of the Gaza people, and I didn't ask them in this case, but in a prior case I asked them, in Gaza you have a court you are an organization for civil rights. What are you doing in Gaza as far as civil rights are concerned? What are you doing with our the dead bodies of our soldiers whom you keep, and you even do not disclose whether they are in your hands or not? Are you active there as much as you are active in our jurisdiction, being an organization for civil rights who is organized in Gaza and just make petitions in Israel and not in Gaza? But I'm just leaving it like that.